Okay, good evening, everybody. We are here with Real Talk 7, Landlords, Tenants, and Our Courts. I am Hilary Bendick with Grassroots Justice of South Hills, and I have with us 3 of the 4 panelists who are going to be joining the panel tonight. We have one more coming soon. So I am going to briefly introduce them and then let them tell us a little bit more about themselves, because I'm really excited about this panel. Because everybody we have tonight is actually experts in this field, which is super exciting. So we have here tonight Dan Vitek with the Community Justice Project. And we have then down below Judge Mick Pappas, who is a magisterial district judge and also a candidate for Court of Common Pleas. He's part of the Reform Coalition. And we have Professor Jerry Dickinson, who is a professor at the University of Pittsburgh, and he's also a candidate in the 2022 election for Congress. And so I'm excited to have, these are 2 of the 3 candidates. And we have one is popping in right now. Coming from another event. So joining us right now is going to be Hilary Wheatley Taylor, who is a candidate for magistrate in Mount Lebanon and Dormont. What I always do now is let the panelists, because everybody here is kind of on a mission, has something they want to tell us about, something to get you guys to be motivated about. So I always kind of stop and top and work my way down. Dan, you work for a great organization, so why don't I start with you and then we'll get to the candidates.
Okay, well, sure. Thanks for this opportunity. It's great to be here tonight. I work at the Community Justice Project. I'm a staff attorney there. We're a statewide legal aid law firm that represents low-income residents who well, I guess the best way to say it is we seek out impact litigation that would help a broad group of people through civil legal representation. So think class action kind of lawsuits and things like that. We don't charge for our services, and so we represent only folks who wouldn't otherwise be able to afford to litigate that issue. Maybe an example or 2 is the best way to really give you a full picture of what we do. Right now, I'm litigating a case regarding language access to subsidized housing. Some displaced residents from Puerto Rico in the Pittsburgh region, and we're lucky enough to find some subsidized housing here, but haven't been given any translation documents, no interpretation services, really sort of being nitpicked by management, trying to, some allegations of direct discrimination, but something that the Western Pennsylvania really hasn't seen a lot of is enforcement of people's civil rights to have government documents in their own language. So that's just one case that I'm working on. I organize tenants around, fighting habitability issues, not just individual concerns, but if a housing complex has, say, no water, no heat, landlords not fixing leaky roofs, things like that, we'll try to organize them and file a lawsuit against the operator. And then I guess the last thing I'll say is, we do a lot of work with mobile home park residents, trying to organize the residents of those parks, to fight rent increases or habitability issues across the state. So, and we're always looking for more cases. So if people have issues that come up in their community and they want to talk to me, feel free to look us up online and just give me a phone call. Thanks.
Great. Okay. Jerry, why don't you tell us a little bit about yourself, your campaign coming up, and I know you have endorsed one of the candidates here.
Yes.
Tell us about yourself.
Yeah, sure. Thanks so much for having me. Really happy to be here to talk about these really important issues. And so, yes, I've endorsed one of the candidates, of course, Judge Vic Pappas. So we're good friends, and so I'm happy to be on with Judge and everyone else here. So I'm Jerry Dickinson. I'm a law professor at the University of Pittsburgh School of Law. I teach constitutional law, property, and race in the law. I practiced at the law firm Reed Smith for some years. I clerked for a federal judge, and I was a Fulbright scholar to Johannesburg, South Africa. So a lot of my work right now involves issues related to constitutional law, looking at issues of gentrification and housing and inequitable policies, particularly here in the city of Pittsburgh. As a faculty member at Pitt, I'm also an activist and an advocate, so I do a lot of work in the communities, in particular doing a lot of police reform, and I utilize my law students along with me to help do that. And currently I'm also working on a number of projects seeking reparations for historic Black churches here in the city of Pittsburgh to rectify decades of discrimination. And so really excited about that. Recently, I published a piece in the Public Source, which is entitled "Pittsburgh is America's Apartheid City," a provocative title, which I think captures much of what's happening in this city in terms of gentrification, segregation, and racial inequalities. And I'll talk more about that here today. And then finally, yes, I announced a candidacy for the United States House of Representatives in Pennsylvania's 18th Congressional District. The 18th district for now, it's probably going to change its number because of redistricting, but it incorporates all the city of Pittsburgh and the outlying areas as well. So we're running a very progressive racial justice campaign here in Western Pennsylvania. And there's never been an African-American congressperson from Western Pennsylvania before. So we're riding on some history here as well. So that being said, thanks for having me. I'm really excited to be here. Thanks.
All right, and Judge Pappas, tell us about yourself, your campaign, and what you have, or just about your campaign for now.
Sure. Hi, everybody. Thank you so much for having me here. It's a pleasure to be with you once again. My name is Mick Pappas. I'm a magisterial district judge representing 8 neighborhoods in the city of Pittsburgh, East Liberty, the neighborhood where I was raised, and the surrounding area. I am currently a candidate for the Court of Common Pleas here in Allegheny County. Here in Allegheny County, we have 9 vacancies on our Court of Common Pleas this year. This represents an incredible opportunity to reshape, reprioritize our local justice system for the next 20 years to come. This would be the equivalent of replacing 2 or 3 Supreme Court justices all at once. And we know from recent history how much that shaped the dynamic of our Supreme Court, or reshaped it, I should say. And so that is the implications for this year's Common Pleas election. I encourage everybody to learn about how they can support reform-minded candidates, because in order to reshape our court and to get on the right path, we need to put 9 reform-minded candidates into those seats. And that is what I represent. I was first elected as a magisterial district judge in 2017. And I ran on one of the platforms that I ran on was increasing access to affordable housing. And since then, within my first year in office in 2018, I was able to reduce evictions in our district by 40% by taking a restorative approach, allowing our courtroom to be a forum for restorative justice. I know that 70% of the landlords in Allegheny County are mom and pop landlords having 10 units or less. And a lot of the folks coming into landlord tenant court on the tenant side are low-income tenants. These folks are seeking some remedy short of the most harsh remedy a judge has available to resolve a dispute. It's not always what we need to do, which is to fast track to an eviction. There's always ways short of that to solve problems, at least oftentimes there are. And so I allowed my courtroom to be a forum for restorative justice to get to those answers. When the pandemic hit in March of 2020, I had been working with a group of mediators, referring cases to them and working out kind of protocols for how to do good mediation referrals. And when the pandemic hit, our courts closed. Access to justice was completely foreclosed. And this just speaks to the power of restorative justice. I reached out to these folks and I said, look, there's no access to justice right now for landlords or tenants. What can we do? I sent them a memo describing the scope of the problem, that 1,000 landlord-tenant matters that would be filed in Allegheny County a month would not be able to be filed, and there were 500 more sitting in the courts that were going to be continued indefinitely. And these community leaders, these strong advocates, they jumped at the occasion to provide services for the community. They formed an organization called Just Mediation Pittsburgh that now has 70 trained community mediators throughout the county. They have 3 staff and have a 95% success rate for mediating landlord-tenant matters. And so this is the power of restorative justice. We have the power to do that all over Allegheny County by electing 9 reform-minded judges to the Court of Common Pleas this May 18th. Look forward to this discussion with so many great advocates who have so much informed my approach and continue to this day.
Great. All right. And Hilary, we grabbed you, from one event to another. Why don't you tell us about yourself and your campaign?
Sure. I'm the other Hilary tonight. Almost all the time these days, I'm the other Hilary. I am a Mount Lebanon resident running to be elected to the Magisterial District Judge seat in Mount Lebanon and Dormont that is open as a result of a retirement of an 18-year veteran on the bench. And I have spent the last 15 years of my career working in real estate law, in landlord tenant matters, and all sorts of other property related litigation matters. And I'm running because I'd like to take my litigation experience and the progressive democratic values and the views I have about the ways magisterial district judges can play a role in court reform from within while we wait for Harrisburg to reform from outside, to the role of magistrate here in Mount Lebanon and Dormont. And I've been talking during this campaign about why members of the community should care about the magistrate, because I get that question a lot. Why should I care about the magistrate? I don't even know where the courtroom is. And I say to people that we are all more likely to encounter a magistrate in our lives in Pennsylvania than we are any other judge in the judicial system. And so who we elect to that role matters. And what Judge Pappas just said about how he was able to change the eviction rates in his district in such a short amount of time speaks really truth to that idea that who sits on the bench and the values they take to the bench matters for the people who live there and matters for the people who drive through it and who visit and work in the communities. And so I want to be the next magistrate in Mount Lebanon and Dormont, and I'm thrilled to join these well-educated and well-trained and experienced gentlemen for this conversation tonight.
Yep. So I'm actually hoping this is one where I talk, very little. I like to ask these questions, but I've got, 4 panelists this time who are all experienced, and I'm the one in the room with, 0 experience in landlord tenant matters and real estate and housing. So, kind of to start this off, this is obviously, an area about, rentals, landlord tenants. And, what we keep seeing in the news is that in Pittsburgh, there are now more people renting than there are owning in the city. And this is also starting to be the trend in Allegheny County in general. And do we know, I guess maybe Jerry, starting with you, since you've kind of been researching housing trends in general, do we know what's causing this trend, in the housing market?
Yeah, sure. So the easy answer is no. We don't know yet exactly what is causing that, but there are some theories. There are obviously some empirical data that might kind of guide us in a particular direction. One thing that we're seeing in Pittsburgh, and this goes back to the question of gentrification, is that we do have, and consistently are having, an influx of relatively younger professionals moving into the city of Pittsburgh. Okay, so that in and of itself is actually causing somewhat of an increase in rentals and those who are actually renting rather than buying, and a significant number of those who are moving from outside of the city into the city of Pittsburgh obviously are choosing to rent for a certain period of time before even buying, or just deciding to rent, generally speaking. So that's obviously one thing. The problem and issue of gentrification. So we do have issues of generational wealth being dispersed and displaced out of some of our long-standing neighborhoods, particularly in the city of Pittsburgh, and those who end up getting displaced due to gentrification, higher costs in housing. when their parents, for example, either sell their house, or when their grandparents pass away, or whatever it may be, that ends up getting sold off to someone else, typically a private developer or someone else who's much more wealthy. And we see that children, oftentimes, those obviously who are adult children of parents, moving out, getting displaced, and then being unable to purchase a home, they actually end up renting as well. So those two dynamics we see playing out in Pittsburgh as well, at a faster rate than the many other jurisdictions and localities throughout the United States, which is very interesting, given that Pittsburgh has always kind of been seen as the nation's most livable city. And so while that is true in some regards, we're not necessarily seeing that for some of those who are at the bottom rung of the economic ladder, who can't keep up with rent and who are being displaced as a result of that. So those are just two aspects of the question of why we have an increase in renters. And obviously there's a lot of policy solutions that, could help to stem that tide. But at the end of the day, we also, I think it's good to understand that the paradigm shift from home ownership to rental is not necessarily a bad thing either. I think the American dream, the idea of the American dream has always been that home ownership is imperative, and you have to own a home in some way, shape, or form at some point in your life. And what we're realizing, of course, is that that may not necessarily be the case, and that we find that folks are finding that renting may be economically a better option for them in the long run as well. So those are just some things that I'll start off with, and of course you can hear from everyone else. So.
Right, and then how is this trend of more renters than owners? How is that having an impact on the court? Maybe Judge Pappas, you can comment on that. Have you noticed, since when you took the bench in 2018, have you noticed more litigation in your courtroom?
I think the question is more of what kind of renters, because by and large, the folks who end up in landlord-tenant court are what they call NOAA renters, which is naturally occurring affordable housing. Well, that's not entirely true. We see that from the recent Pittsburgh Foundation report that the vast majority of cases are filed against folks who have subsidies, such as Section 8. But that, I think, is just a product of which landlords tend to file the most. And I think that's changing as well because of some practices that, for example, the City of Pittsburgh Housing Authority has adopted, such as making their due date in the middle of the month instead of the beginning of the month, things like that, which is a suggestion that grew out of a town hall that Mr. Vitek and the professor also joined us on. So there's real outcomes that you can expect by just engaging the community on these issues. But in any event, I think the question gets back to what types of renters are these new renters, and I think it's largely going to be renters who, like Mr. Dickinson said, are higher income renters moving here from, because they obtained a job with the university or with a business. These are folks with undergraduate degrees and things like that. Because I represent East Liberty and the surrounding area, Upper Lawrenceville. We've seen just a great deal of displacement in the area that I represent. And I would venture to say that in the district that I represent, overall renting in terms of number of units has probably gone down in the last several years. And what we're seeing is fewer landlord-tenant cases being filed because folks are market rate renters that generally aren't the ones ending up in landlord-tenant court. Perhaps the increase in the overall number of renters relative to owners also has to do with kind of new development that's occurring in places like the Strip District, places like downtown and areas like that. But from my perspective, I've seen a lot of market rate renters coming in, and just as many, if not more, low income subsidized renters leaving. That's what my observation has been.
Okay, so in terms of also displacement, Jerry, you had mentioned earlier one of the articles you had written was about, Pittsburgh is America's apartheid city. So you've addressed, the racial disparities in Pittsburgh, and that Pittsburgh is largely a segregated city in its housing. Can you kind of explain, how did we get so segregated in Pittsburgh? And that might be a loaded question, and I probably could go on this whole hour, talking about that. But maybe if we somehow could get, I don't know if there is a long and short of it, but maybe I'm asking too much.
No, it's a great question. Pittsburgh is one of the most segregated cities based off of, when we talk about white-black residential segregation. Pittsburgh is one of the most segregated in all of the United States. And we have a long history of discriminatory practices like many major cities. And those practices include long history of redlining by the private mortgage insurance industry, the federal government. We have a long history of racial steering by real estate agents and realtors, actually pushing Black families out of white neighborhoods and steering them into concentrated Black neighborhoods for home ownership opportunities. We have a history of exclusionary zoning in the city of Pittsburgh in particular. That is the kind of de facto separation of renters from homeowners. And as a result of that, what that has created is a de facto kind of racial zoning in the city, where you have the disproportionate number of folks who are African American who are renting, disproportionate number who are white who are homeowners, and as a result of that, we see separation based off of districts and zones. It's a very fascinating history here in Pittsburgh. We also, on the outskirts of the city, so this actually has spillover effects from the city of Pittsburgh into the Black suburbs. So for example, Clairton and Wilkinsburg and a number of other places, Braddock and Rankin, we've had long history of federal subsidized housing discrimination where African Americans have been discriminated against and oftentimes pushed by public housing authorities into these concentrated enclaves of public housing projects. A long, long history of this here in the Black suburbs on the outskirts of the city of Pittsburgh. And then we also have a long history of school segregation. So Woodland Hills, for example, which I just moderated an event for the candidates there for the school board, was effectively created due to a school desegregation order by a federal court. Judge Vitek was the lawyer who actually litigated that, and that effectively required that you consolidate what was prior to that a segregated part of the region based off of white schools and Black schools. And so all of these things combined, I like to think of it as a confluence of segregated and discriminatory practices, has effectively created, again, one of the most segregated regions in the United States. But that's not it. And I always mention this, is that Pittsburgh, it's not about being one of the most segregated cities, because there are many segregated cities all throughout the United States, right? Boston and Chicago and many others. What puts Pittsburgh on a completely different plane or a league of its own is the racial disparities that exist within and across the segregated landscape. And so in other words, when it comes to health outcomes and education and income and housing and a number of other factors and indicators, African Americans fall at the bottom in all of those different aspects of health and well-being. And because of that, and that's largely due to the segregated environment that we've created, we've also created vast racial disparities, and they're only getting worse. And so that's what kind of creates Pittsburgh as this kind of apartheid, new American apartheid city. It's not directly the South African apartheid of legal strictures that you see in an apartheid era, but it's a kind of a new modern American apartheid where you have segregation and then vast racial inequalities in that segregated landscape. And, as I say in the piece, we have a moral reckoning upon us here in Pittsburgh when we realize just how bad it is for a large subset of the population. That means that, public officials, the philanthropic community, the private sector, the business sector, the medical field, we've really got to pay attention and have sustained attention and addressing these problems over time in order to do that. And as I say, now I'm putting on my candidate hat, is that our goal here in this region is to one day become a world-class region of racial equality. That really is kind of the moral calling and moral imperative for our region. And you know, I'm excited about it because all the folks on this call obviously are going to play a role in that. So,
Right.
Yeah.
Yep. Okay. So, so obviously one of the ways, you know, landlords can, you know, kind of maybe take advantage of tenants would be an eviction process. Hilary, you've been practicing, you know, in the courts. So just process wise, what is the process when a landlord wants to request an eviction of a tenant? Is there, you know, a certain standard that has to be proven when they want to request an eviction?
It's the same sort of standard that's present in any civil litigation that's brought before the magistrate or the court of common pleas, which is preponderance of the evidence. So if you're thinking about a scale, it's just slightly, one side is just slightly higher. That's all you need to prove and win a civil case. So when it comes to landlord tenant eviction cases, the landlord has to prove that there's a lease of some kind, written or oral lease relationship, what the rent is, what the security deposit was, if any, and the basis on which they are entitled to possession, whether it is non-payment of rent, end of lease term, or violation of some other term of the lease, whether it's related to conduct or condition of the property or residence in the property. And, you know, because magistrates are not a court of record, sometimes the rules are different from magistrate to magistrate. That's not right. That's not how it should be. But you can present that right now, as we sit here, you can present the same case to 20 different magistrates and maybe get 20 different results. And the lack of transparency and consistency in those decisions has to be frustrating for every single participant because you can't predict what the result's going to be. And because you can't do that, you can't advise your client of what their remedies are and what their rights are. And so, you know, it's a simple process. Like I said, the standard is the same, whether it's a landlord tenant case or civil litigation matter, just that 51%. You got to convince a magistrate 51% is the evidence.
So how then, I guess, Judge Pappas, as a magistrate, do you weigh, if there's no standard? I guess it's very confusing to me. Do you then weigh that somebody has met the burden of eviction if it's not for non-payment of rent? And then you're on mute, but that also seems to me that that is just wrought for, you know, tenants to be taken advantage of.
Well, the rules of evidence are the same in front of magistrate district judges, with few exceptions. Certain documents are admissible under our rules of procedure that otherwise wouldn't be in front of a common pleas court. I would argue that it's fairly easy to predict the outcomes in landlord tenant cases in magistrate district courts. 90% of them end in a judgment for possession. So I think that, you know, the outcomes are oftentimes fairly predictable. And I think that Ms. Wheatley Taylor is exactly right, that the burden is on the plaintiff to prove their case. And so that's always the starting point. And so the first question is, what is this case about? Most often it's framed from the plaintiff's perspective as non-payment of rent, but of course, oftentimes the defendant has a different perspective on that. Perhaps the defendant has withheld rent. Perhaps the defendant doesn't agree on the amount that's owed. Perhaps there's been a communication breakdown of some kind. You know, this is where you really have to, as a judge, be a great listener to understand what the conflict is, right? And what the sources of the conflict are. And so for me, my practice is to give persons their opportunity to be heard in court, right? Because that's what they're there for. They have a dispute, and this may be the first time they've come together to air out their grievances with each other. And so one, you give people space and time to have their opportunity to be heard. And at the end of the hearing, a judge generally is supposed to announce their disposition, unless they still have to do some research or think about it more, review their notes, so on and so forth. And so what I would oftentimes do is say, well, here is what I'm thinking about the plaintiff's side of their case, and repeat to them what their position is. Here's what the defendant's position is. And, if I'm not able to make a decision today, I'll make it within 3 days, which the rules require. At the same time, here's what I think this conflict is about. There are weaknesses on both sides of this case. Here's a possible resolution that you might want to consider. And that's where a discussion begins. And if there's no room to reach that consensus, then the court can decide the case, and that's not a problem. But oftentimes there is some kind of room to reach consensus, and the parties oftentimes want to explore it once they've had their opportunity to be heard. And so I think that's kind of the technique that has worked for me, just kind of giving folks space and opportunity to be heard, giving them enough time to have that hearing, allowing them to present their evidence and go through the rules of procedure and the rules of evidence to get there. This is what the likely result will be, but then also consider that appeals and so forth can occur, and litigation is costly and time consuming. One last thing I'd say is that not only did we reduce the eviction rate by 40% in my first year in office, but something else changed, which is that the number of appeals taken from our office in landlord tenant matters remained roughly the same, but the year before I took office, 100% of the appellants were tenants. Whereas the year after I took office, it was 50-50, right down the middle. So, which I think speaks to kind of taking a fair approach in these cases, giving folks an opportunity to be heard, and just realizing that a lot of these mom and pop landlords don't necessarily know the rules of court and the rules of procedure, and make mistakes that expose their case to possible disposition that would not be favorable to them. And so there's always room to kind of work with the parties, because there's oftentimes weaknesses on both sides of the case.
As a side note, I was probably representing one of those tenants in one of those 2016 appeals from your predecessor. Most shocking result I've ever had in a litigation case, and it was just a landlord tenant case from before a magistrate.
Yeah, it goes down in district court. I can tell you that for sure.
Yep.
Well, if I could just pop in for a sec, I want to comment, sort of going back to what Jerry was talking about, and this idea that renters are becoming more common, and how does that affect the court? It requires a shift in our perspective on what tenants are entitled to in terms of the rights under the law. And that I'm not talking about from Harrisburg. I'm talking about from the individual judges and how they view the situation. If you're someone who only rented when you were in college or just out of school, starting your career, and then you've enjoyed the luxuries of home ownership since then, I think you can quickly lose touch with the value that a tenant puts in renting their home. I think Mick was talking about the situation earlier before the call started, of folks who have been renting the same unit in the same neighborhood for 16 years. And then, there's a switch in ownership of the property, and the tenant's out, and that's that, right? But from the perspective of the court, you can't view these contracts as, simple consumer contracts that are just a piece of paper and can disappear as soon as one party decides that they're sick of it. They're enforceable contracts, just like $1 billion commercial contract, where you're going to get a bevy of lawyers on both sides fighting tooth and nail and charging huge litigation costs. You're not going to see that in a landlord tenant matter, but the importance of keeping a roof over your head is so great that I expect judges to consider the law and the details of the case as if it was that $1 billion case, because to the individual tenant, it could feel that way. And so I just point out that, someone like Hilary, who just knows landlord tenant law inside and out, she knows that these aren't simple cases. That, yeah, it's the end of lease term, says the landlord, but it requires a real review of that contract, a look at the case law as to, when does a lease end? When does it automatically renew? Are we truly at the end of the lease, or are we in another term? Has the landlord followed all the procedures to terminate this lease, or has the tenant relied on the landlord's actions and is entitled to more time? These are very complex questions, and they require a judiciary that understands the complexities of the law, is capable of applying the law, and has the consideration and understanding of what it means to be a tenant, considering how many more tenants there are these days. To sit down and listen, like Mick's done in his at his court.
Can I just say one thing? Not so much a response, but to add on a little bit. One of the first things I did when I came into court, into district court as a magistrate, was I changed the way we scheduled hearings, so that we weren't piling cases on top of each other, what they call case stacking, but we were staggering them throughout the day, dedicating an entire day to these hearings and making sure that people didn't feel anxious about being heard, not having enough time. Number two, I would say I have seen some landlords get taken to the house too by very savvy tenants who knew the law very, very well. And I know if we're being honest, and we practice in this area, that this happens. And so there really is a benefit to, at the district court level, trying to take a conciliatory approach where possible, on all sides of the case, really.
So I have 2 points. One, that was a good point you made, Dan, about people losing touch about the complexities of a lease, because I think that I'm one of those people, because I think of, just in my mind, college or, law school, you have that lease, you pay your security deposit, you're never going to get it back because, those landlords, they're dealing with 100 crappy tenants and crappy leases. And so you just leave the place and you never think about your security deposit. But now, with so many renters, they have actually nice places, they're investing in them. And, so it is way more complex. So that's a good point that you made. But two, my understanding is in magistrates, landlord tenant is essentially what, one fifth, like it's a whole day of your practice, correct?
Mick, you're muted. Or Judge Pappas, sorry.
Okay. It's a significant portion of our caseload, but it also depends on the court. I think our court has, we're in the top probably 3/4 in terms of the number of landlord tenant filings in the county. It depends on the nature of the jurisdiction as well.
Yeah, I think the statistics for the Mount Lebanon Dormont district, the ones that we most recently available statistics from 2017, 2018 suggest it's about 20% of the docket. The large portion of which is taken up by traffic citations and parking citations, but.
Yeah, so it's an important component of the caseload. Okay, so we mentioned, that landlord, there can be both sides. The landlord, could, get taken advantage of. But, are there cases, do you guys see in court that Section 8 or public housing cases might get more complaints from landlords, or more cases in the courtroom? You always hear those stories or see the articles in the news. Does that happen?
My experience is that if the Section 8 landlord is keeping up with their end of the bargain, which means that they're maintaining the property in a way that passes the housing authority standards, I find that there's very little litigation around evicting tenants by the landlord. There can be quite a lot of litigation around the housing authority trying to terminate the tenant from the program, but that's not an eviction action. That's a separate legal matter. But for the most part, I see very little cases where the landlord is seeking to throw a tenant out who has a voucher, an active voucher, when the landlord hasn't defaulted on their obligation to maintain the property. Public housing, on the other hand, is a completely different story. The complexities of that type of housing are immense, and it trips up tenants constantly. And then you have to add to that sort of what I call the bureaucratic indifference, the cruelty of bureaucratic indifference, where you have people who see their job as just pushing evictions, or making sure rules are followed for the sake of following rules. And when, you have a program that's complex to follow and comply with, and you have someone, trying to evict you for not following every little rule, you see a lot of friction and a lot of evictions filed because of that. So, I guess the question is answered depending on the housing program you're in. You can see a lot of eviction action where you can see very little.
And just for people who don't know, what is the difference between Section 8 and public housing? Because sometimes I feel like the words end up getting used interchangeably and they are not the same.
Yeah, right. Good point. So when I talk about public housing, I talk about housing that is owned and operated by a public housing authority. In Allegheny County, we have 3 public housing authorities. We have the Housing Authority City of Pittsburgh, which is within the city limits. We have the Housing Authority of McKeesport, which is a smaller one within the limits of the city of McKeesport. And then we have the Allegheny County Housing Authority, which is everything else within the county that's not covered by those 2 other jurisdictions. And all 3 own property and maintain property as rental units, and that is public housing. Your relationship with the public housing authority is your landlord-tenant relationship. With Section 8, as they call it, that's the colloquial term. Really, it's called the Housing Choice Voucher Program. Essentially, the tenant is in a program with the public housing authority where the tenant gets a voucher and then goes out to the private market, finds their own housing. The landlord and tenant relationship is between the tenant and the landlord only, but the voucher is used so that the landlord gets paid the remaining balance on the market rate rent from the public housing authority. That way, as the tenant's income fluctuates, their rent will go up or down, but the landlord always gets paid the full market rent, part by the tenant and then part by the housing authority. So think of it as just, Section 8 is the.
Let me throw it out with Mr. Vitek and then throw it over to Professor Dickinson. Public housing is like the VA, and Section 8 is like Medicare. And so what Matthew Desmond was promoting was Medicare for all and evicted, basically, but in the housing sense, which is public funding, public provided when it's public housing, public funding, private provided when it's Section 8. So, and then with that, I would invite Mr. Dickinson to weigh in, since I invoked Medicare for all.
No, I was just going to mention, which I do agree about that. Yes, Medicare for all. Go. Yes. A big policy point for us on this campaign. But I was going to say, Section 8 in public housing, what I've experienced in my work representing tenants, and I still do represent select tenants as a law professor, and certainly Dan and Hilary will agree with me on this, is that when you're representing tenants in public housing or Section 8, there are separate rules, regulatory rules and procedures, separate from what you'll find under the landlord-tenant law here in Pennsylvania. And those rules and procedures can be very helpful and effective in actually crafting, creative arguments on behalf of your client. And many of which oftentimes judges aren't really privy to and understand. Certainly landlords and some of their lawyers who are representing them also sometimes don't really understand the complexities of the regulatory apparatus of public housing versus Section 8. And I found a lot of success by maneuvering using certain exceptions and exemptions and other rarely used exemptions to help a tenant out. And so, that's one of the benefits, I think, of having that massive apparatus of the public housing in Section 8 procedures, is that you really have an advantage in representing the tenant as well. And so, and Dan and I have actually worked on a number of cases where we've actually utilized some of those exceptions within the rules to on behalf of a tenant. So
Now, in housing though, there isn't a right to counsel, right? In landlord tenant matters?
no, there is not. It's not a civil. Yeah, there's not a civil right, not a civil Gideon. You know, there's a right to counsel in criminal proceedings, but that's changing. Across the United States, there is a bit of a movement towards a right to counsel. In New York City, for example, they passed a law which provided for funding for a right to counsel. And this is something that's been taken up by a number of other jurisdictions as well to provide that type of assistance. Today, I believe the number still is around 95 to 96% of tenants are unrepresented, and which is, you know, clearly problematic when we're talking about issues related to gentrification, but also the impact that evictions have on so many people. And as Judge mentioned, Matthew Desmond's work in the book Evicted really kind of sheds light on the fact that African-American women in particular, poor African-American women, are at the most disadvantaged in the housing market, particularly when they are evicted. Eviction in and of itself actually in many ways is a spiral downward into concentrated poverty. And we're seeing that over and over and over again in many major metropolitan areas throughout the United States. And going to the policy ramifications for that, that's why it's so important that we start to rethink housing law and rethink the way that we go about allowing for laws to be so advantageous to landlords at the disadvantage of tenants. So.
And you know, if I could add to that, that the reason it's so important for, you know, judicial elections to consider the candidates' policies on landlord-tenant practice is because even though you don't have a right to counsel, there's lots of things that the individual judges can do to assist or to make it easier for tenants who want to get counsel have that opportunity to do it. If you're just, you know, the rules of court say that you have to have a hearing within 7 to 12 days of the filing. That's a really fast period of time, but they give the discretion to the judges on how they're going to schedule those, whether they're going to schedule them all at once and have sort of a free-for-all and make, you know, tenants and landlords wait, you know, all day to perhaps for their hearing. And it also gives the judges discretion on whether they're going to grant continuances when parties don't show up or when attorneys aren't available, et cetera, et cetera. And so if you're a judge that's concerned about having representation at these hearings because you think it's an important legal issue and an important matter in people's lives, then you can have a pretty big impact just based on how you schedule things and how you're willing to proceed in your cases, how quickly. So.
Yeah, and to that point, Dan, I think that, you know, when we talk about landlord tenant cases and eviction and possession, what we're really talking about is one side is trying to make the other side homeless. And I think if judges remember that possession decisions might result in someone not having a place to live, even if they're justifiably, you know, even if the facts and circumstances suggest that a possession order is granted, giving people more time to get counsel and find resources and help does a lot of good in the long run. And that's what I'm constantly counseling clients who are coming to me wanting to evict tenants, because our real estate practice is in large part on the landlord side out of, you know, decades long history of client representation, and their frustration at how long the process is and how the rules seem to provide so much leeway to tenants. My constant refrain is, I understand you own this property and you have a mortgage, but you're trying to make somebody homeless.
Is there a rule, so if a judge or a magistrate, and I'll ask the two judicial candidates here, you know, you have a pro se tenant in front of you and you have a landlord who might be who is represented, and you feel from the bench that, you know, there might be, you know, a misuse of the system, or that, the landlord, perhaps is, taking advantage of the fact that the tenant, is not aware of his or her rights, or their rights. Is there a role that magistrates and judges can play in ensuring that tenants, unrepresented tenants, are aware of their rights in that circumstance, even though they don't have counsel? Like, are you able to, can judges and magistrates, help tenants be aware of their rights?
Go ahead,
Well,
Judge Pappas.
Sure. Well, we can't provide legal advice, right? And we have to be fair to both parties, even if one party has an advantage in terms of knowledge of the law and there's a disparity in power within the relationship, right? But these are all, and it depends on every case, right? But these are all legal issues as well, in terms of unconscionability, consumer protection. How is a party behaving in their contractual relationship? And what are the specifics of the case? One thing that judges can and have been doing in Allegheny County, magisterial district judges in particular, and Mr. Vitek and Professor Dickinson know about this because they helped with the event that I mentioned earlier, is educate the community about procedures and landlord-tenant matters, generally, right? And providing the same information to everybody. We worked with Pennsylvanians for Modern Courts a couple of years ago to host a series of educational forums. Mine turned into a whole town hall, and with panelists and everything. And out of that also came kind of a booklet about kind of what procedures are in court cases before district judges and landlord-tenant matters. And there was a section for the landlord, a section for the tenant. It was a pretty accurate booklet. I mean, there's always more you can add to it because these are complicated matters. These are not just kind of, you wave a lease around and say, hey, judge, I need a judgment. That's not how it goes. It's not how it works. These are legal matters, and you're right. Somebody's housing is on the line. Somebody's property is on the line. And so, yeah, there are things that judges can do aside from simply just deciding cases, right? Public education is really important. Having a presence in the community is really important. Being faithful to the law is important too, even if you personally don't like the result, right? One last thing I would say though is that, I mentioned the mediation program recently as an example of being involved with the community and helping educate the community as a judge. Mr. Dickinson mentioned earlier kind of this reckoning, and we are in an era of reckoning. And this makes it incumbent upon the judiciary to show leadership from the bench and to lead us into an era of reconciliation, truth-telling, and reform. Not speaking to reconciliation and truth-telling in the terms of the truth and reconciliation and apartheid, but maybe there's a connection there. But we have to get from this era of deep distrust with our justice system to an era where people are confident in our courts and our legal system again, and don't believe there's two different legal systems in our country, one for Black folks, one for white folks, one for poor folks, one for rich folks. That is in fact one legal system that applies the same to everybody.
Mm-hmm.
So you mentioned this mediation program. Was this something that you created yourself? Was this something already within your magisterial district? How did you, manage to come about creating this? And, reduction by 39, it was almost 40%. It's amazing. Give us more details, than what we've already heard.
Sure. So in terms of the reduction, the interesting thing is that tenants won their cases in terms of a judgment for the defendant pretty much just as often. What you saw was a huge decrease in the number of judgments for possession and a huge increase in the numbers of settlements, dismissals by agreements, and withdrawals, because parties were having a chance to have their day in court and be heard and reach an agreement. So really, it wasn't like, all of a sudden Judge Pappas is finding for tenants all the time and against landlords. It was actually just this conciliatory process where parties were settling, withdrawing, or agreeing to a dismissal of their cases. There were instances where, of course, I dismissed cases that procedurally were inadequate in terms of failure to provide notice to quit and things like that. And sometimes the party has to learn the hard way how to follow procedures. But But in terms of the mediation program, I can't be credited with starting it, but I'm proud to have helped a little bit. There used to be a mediation program within the Magisterial District Courts with the Mediation Center of Pittsburgh. And then Mediation Center of Pittsburgh went by the wayside, and that program went with it. So what I immediately tried to do upon taking office was try to kind of recreate some semblance of it, working with Centers for Victims of Violence and Crime and working with individual mediators in the community, including Professor Judith Teeter at the University of Pittsburgh School of Law, Selena Schultz at the Conflict Lab, and others. And so we kind of worked diligently and deliberately on creating a protocol that made sense, where we weren't engaging in ex parte communication, where we were cognizant of the rules of procedure that applied to how long a case has in a district court in terms of timelines, 30 days before a disposition in landlord-tenant matters, so on and so forth. But then the pandemic hit, and now we're kind of tinkering with the process and protocol. All of a sudden, like, there was much more urgency to getting something going. And so, like I said, I authored this memo just describing the scope of the problem. Matthew Desmond, who we mentioned earlier, described it as predicting a tsunami of evictions in an article he wrote in the Washington Post. And when impressing this upon these stakeholders and upon others who got involved, Pittsburgh Human Relations Commission got involved under their previous director, they just took it and ran with it. And they raised $350,000 from foundations and otherwise, legal aid sources, some of the initial CARES Act money from the city. And now they have this institution. The only thing I would add, though, is that one of the problems when I first came in is that district courts were kind of viewed as a pass-through because there was funding available to help prevent an eviction for non-payment of rent, but it was money from the federal government coming through the state, coming through the county for homelessness prevention. And it was almost always the case that you had to have a judgment for possession before you would become eligible for that money. But now something else has happened at the local level. Funders and even the local government started coming up with funding through for eviction prevention, not homelessness prevention. So now it's funding that's available on the front end. And you had a massive expansion of this with the CARES Act and other relief that's come down since the pandemic hit. And you've seen a huge decrease in the number of evictions. And now people are starting to realize, and I'm starting to realize, there is another way to deal with housing disputes. You know, what we need is massive funding from the federal and state government on an ongoing basis to prevent evictions, right? And we now have semblance of an infrastructure in place to do that because we've been working on it for a year at the community level to put this eviction prevention rapid response infrastructure in place. It would be a horrible shame if this all fell by the wayside once the pandemic subsided, and we just kind of forgot everything that we'd achieved in the last year in terms of how we can take another course and ensure that all parties are made whole, but nobody is homeless in the end, right? On the front end, not on the back end.
Right. Yeah, I mean, I think that, certainly your conciliatory approach, is always the best approach. And you said you had also reduced the appeals in that process.
I think the rate of appeals remained relatively the same, at least in the first year. But the difference was that it went from being 100% of the appeals being tenant appeals to 50% being tenant, 50% being landlord. And so it was kind of a huge kind of difference in the party that was becoming the appellate and taking it on for de novo before arbitration upon pleas.
Great. Okay. So we always try to then look back to, kind of something we focused on in an earlier series. And one of the issues we had earlier was we had, somebody you had actually, you're running with, Judge Pappas and Hilary Taylor. She was on in our speaker series on mental health issues. What we discuss is how persons with certain disabilities or neurodivergent individuals, they may act in a manner that can often be mistaken for maybe a criminal act, or maybe it could be something that might be mistaken for something that could be a violation of a lease. I'm going to ask a two-part question. What are the rules with regard to tenants with disabilities living in rental housing? Do landlords have to accommodate, and would they be able to evict a disabled or neurodivergent person, for behavior that would otherwise, could be mistaken as a violation of a lease, or could it be mistaken for a criminal behavior?
Dan, do you want to take that?
Sure. The answer is no. Landlords cannot evict based on someone's disability. And if that, if there's a lease clause that due to someone's disability prevents them from remaining in the housing or accessing that housing, then the landlord needs to make an accommodation for that disability, so that person can enjoy the housing equal to the opportunities that all the other tenants have. Now, that's a simplification of fair housing law, but I think that the point to understand is that there's a federal statute, there's a state statute, and it protects people with disabilities from being discriminated against in their housing. And that mostly comes down to if there is an issue with the tenant being able to remain in that housing related to their disability, that they need to be accommodated in some way. And that can be as simple as saying, you have a noise ordinance or, a rule in the lease that says, quiet hours after 9 p.m. And there's an incident where someone has, a mental breakdown, is making, lots of noise, intervention is necessary. And, the landlord can't just say, I'm going to evict, because we have a policy here that says you don't make noise after 9 o'clock, and you did. So technically that individual has breached the lease, but that's where there needs to be an accommodation made by the landlord to say, okay, under this particular tenant's lease, we are not going to enforce that one strike, no noise after 9 p.m. Where, the tenant has a responsibility to, seek out some sort of remedy, so that they can get help and so that they're not continuing to disturb their neighbors. But the landlord has the obligation to accommodate that tenant and not simply evict them for the behavior. And frankly, if any tenants are in that situation, then they should be directed to, a law firm or to the Pittsburgh Fair Housing Partnership for assistance in how to file a complaint against their landlord if they feel they've been discriminated against.
Along those same lines, looking at, some of the stuff that I've read about fines and fees, it seems like, the fines and fees that get assessed on late payment of rent, often could be something that, similar to just any court proceeding, could prevent a low income tenant from being able ever to get current on their rent. Are fines and fees something that a judge or a magisterial district judge, are they something that you have discretion to dismiss, when the tenant and landlord come before you in a dispute?
I take that, Judge Pappas.
I think we wouldn't want to conflate fines and fees in a summary or criminal matter with a contractual obligation of paying a late fee, right? But I think that one could reach the finding that a late fee was excessive, and then reduce it if the late fee is a certain high percentage of the overall rent. One thing that was kind of like a fine and fee, but that has been remedied to some extent through collaboration of stakeholders, was that, and I think we mentioned this a little bit earlier, the housing authority was often in the city of Pittsburgh was oftentimes filing the day after rent was late on the 6th, but folks weren't getting their public assistance until the 5th or the 6th or somewhere around that time. And so there were some folks who would always pay their rent, but they would always just pay a little bit late because of the way their public assistance came in. And they would always have these court cases where the landlord would always file and then court costs would be awarded to the tenant. Now, these are tenants who pay $100 or less per month in rent. So essentially, you're doubling their rent through court costs every time you file against them, and you file against them almost every month. And so it became a huge problem. And I think the housing authority rightfully recognized it and changed their lease so that rent would be due later in the month rather than on the 5th all the time. And I believe this is something they put into place already. And I wish that they would take a look at some of their other lease terms, because these are boilerplate leases, and to some extent, some of the terms are required, by regulation, but some of the terms are discretionary. And it would be great if the housing authority could kind of work with stakeholders like everybody here to take a look at how they could kind of simply modify a few of their terms here and there to prevent displacement, to prevent excessive filing for landlord tenant matters and evictions.
Could I just point out, this is a perfect example of why you need educated judges sitting on the bench, even at the magisterial district court level, because if this was $1 billion case again, absolutely there would be litigation over whether the contract clause that imposed liquidated damages, as they would call it, but a penalty, a late fee, was lawful. There's tons of case law out there debating when a penalty clause or a late fee becomes a penalty, which is illegal, versus an estimate of actual damages. And so to say that you shouldn't apply that level of scrutiny to the landlord-tenant situation, I think is, again, to ignore the severity of what's at stake for a tenant. And so absolutely, I would expect my judge to listen to the legal argument as to why a late fee shouldn't be applied because it's an illegal penalty, and to really give that kind of argument thorough vetting before they rule on it. So it's just, without the legal understanding and background and the appreciation of what tenants are going through, that issue can easily slip under the cracks, and you can just say, hey, you signed the lease, $100, late fee for missing your rent. But I think that could be very much a penalty and needs scrutiny.
All right. And our last question. So pursuant to a 2019 report from the City of Pittsburgh's Gender Equity Commission, in Pittsburgh, they found that more Black children are growing up in poverty than in 95% of other similar cities in the United States. Based on these statistics, I would presume that such disproportionate levels of Black families living in poverty, we must have similar disproportionate levels of Black families also living then in Section 8 and public housing. Do we find then the same disparities in treatment of these low-income Black families in housing court that we find in criminal court? And I guess maybe Judge Pappas, I don't know if you or Jerry, anybody can really comment on this.
I just based off of observations and anecdotal evidence of representing a significant number of African American tenants in housing court and whatever it may be. Yes, I do think, and I have experienced a certain level of mistreatment of African Americans in those circumstances. Obviously, I don't have an empirical number to give you on that, but I do think that is the case. I've had a number of cases before judges at the Court of Common Pleas, for example, where a tenant, a client of mine who was actually a public housing tenant who was being evicted for a breach of lease that happened 4 years earlier, but hadn't been caught by the housing authority until 4 years after. The judge, I recall, almost as if the idea of the tenant, it's almost as if the judge said to the tenant effectively, well, look, you're lucky just to even have this access to this public subsidy, right? Because she was obviously arguing for, the fact that she reformed herself and that, she had really rehabilitated herself after the breach of lease. That the judge kind of, looked down upon her in a way that gave me the sense the judge certainly didn't understand the dynamics of having access to such subsidies, and obviously her being African-American woman in Pittsburgh also playing a role in that as well. So I do see this. I see this as a deep problem, deeply entrenched problem here in Pittsburgh that has underlying subconscious racism elements to it as well. And that's hard to rectify, of course, because of the dynamic of it. And sometimes it can be subtle racism as well. So I certainly see that. And I think it's a huge problem here in Allegheny County.
And then what role can judges and magistrates play in ensuring that, all litigants, including, low income litigants appearing before them are treated fairly and impartially under the law? Now I'll turn to the candidates, the two judicial candidates here.
I think the first and most important thing is for judges to acknowledge the inherent and implicit bias in the system, and the implicit bias we all have within us, even if it's uncomfortable to admit. I just came from a candidate forum run by the Abolitionist Law Center, where myself and two other candidates were asked about our bias. And my fellow candidates participating, both of them denied having any bias. And I think you can't help address the disparities and the bias in the system if you refuse to acknowledge that you have it and the system has it.
Yeah, I'm shocked that a candidate for judicial office wouldn't be able to address and acknowledge their own implicit bias or the idea that they would have it, because it's so important for a judge. I mean, it's just so important for a judge to mind their own deliberative process for implicit bias at all points of decision making, and a judge's deliberative process is privileged. And oftentimes it doesn't have to be disclosed by the judge, but that doesn't mean they shouldn't. That doesn't mean that it's not the right thing to do. And for me, what it is a matter of procedural justice, which is explaining to people why you're making the decision you're making and thinking about it. And part of it is also like you want people to know what their next steps are. If you decide against the party, you want them to know what their right to appeal is, and you want to be able to explain it to them rather than it be just described on some boilerplate document they received in the mail after you make your decision. And so, I'm proud to have been the only judge in Pennsylvania who joined judges in judicial districts throughout the country in releasing a statement in response to the killing of George Floyd. And the statement was straightforward, and it's on my Medium page. It talked about being committed to addressing systemic racism and oppression and bias in the justice system, and ensuring that my courtroom is a place where we're going to address it and acknowledge it. And it's a matter of a judge's judicial philosophy in the end of the day. And that's why judicial elections matter, because judicial philosophies are not all the same. They differ. And if we want to have reform-minded judges on the bench who will lead us into this new era, then we've got to pay close attention to the philosophies that they discuss and talk about when they're campaigning.
Great. All right. Thank you. Okay, so this is the portion of the evening where I ask everybody what events you guys have coming up. So hopefully you guys are ready for this because your campaign managers are not on. So you gotta remember what you have coming up. So as everybody knows, More and Grassroots Justice are advocacy groups. So we invite these candidates on here specifically because we want to support these candidates. And we want you, everybody listening here and on Facebook, to support these candidates too. So I am going to be able to, because it's only me tonight, I don't have my partner from More with me tonight. I'm going to be able to post their campaign stuff here on the Zoom, and then I will immediately follow up on Facebook with their campaign stuff here. So as I am asking them to talk about themselves and their events, I'm going to be asking everybody to donate, please, to these candidates. Bear with me. So Dan, I'm actually going to start with you because we do always ask people who work for great organizations to talk to, just say, well, if their organization has any charitable events, and then I'll get to the candidates. So if your organization has any charitable events coming up, feel free to plug that right now.
No, we don't do charitable events, but can I just plug that we're always looking for cases. You know, if people know of someone who they think is suffering, you know, from discrimination or, you know, consumer issues that relate to low-income folks in our community, feel free to refer them our way. Thanks for the plug.
Great. All right. Judge Pappas, why don't you go ahead and tell us what you have coming up this week, what events you have?
Okay, well, there's a really important event coming up, and it's called Election Day. And that's going to be on May 18th, starting at the crack of dawn and going until dusk. And that's going to be the #1 day that you have to keep on your radar. I would respectfully request everybody give me their deep consideration as a candidate for the Court of Common Pleas. You're going to have to pick Mick by scrolling down to number 26 on the ballot in terms of candidate position. You know, other events that we have coming up, look, my background is in community organizing. That's what I started off doing when I graduated from university and came back to my hometown, resolved to make a difference and to apply my privilege to the community that put me in the position to have it in the first place. I've been knocking on doors ever since, you know, I was a young organizer. I've knocked on thousands of doors all over the country and of course here in Pittsburgh. And I'm going to keep on doing that until the very last second, the very last day of Election Day. So please reach out to us at hello@mcpappas.com. I'm at McPappas on pretty much every social media venue that's out there. And you can keep up with our campaign that way. And if you'd specifically like to get involved as a volunteer, go to mcpappas.com/volunteer. We need an army of volunteers on Election Day to make sure that everybody knows that they need to choose a reform-minded candidate for Court of Common Pleas this year. So May 18th, volunteer, get involved, check us out on the internets, and thank you very much to everybody who's hosted today and all of our friends in the South Hills.
All right, and his website to donate is on in the chat, and it will be on the Facebook Live as soon as I turn this off. So anybody who continues to watch, and you can always rewatch these on my Lebanon Organization for Racial Equity, and it's also always on Hilary's site and on Grassroots Justice's site and South Hills United Against Hate site. But please donate to him because we need him to have his, I assume there's going to be commercials probably somewhere, and also all of his additional needs. All right, Jerry, Professor Dickinson, you are next. Go ahead and tell us what you have coming up. I don't know, I imagine you probably don't have many campaign events next, but we want to make sure we get.
I would say we're trying to stay out of the way as much as possible before the May primaries, since our election is not until May of 2022, which actually could be pushed back even further because of redistricting. So we're trying to stay out of the way and really focus in on the judicial candidates and the other candidates. A lot of what I'm doing now is actually collaborating with a number of the judicial candidates. And so Zeke Rediker, who is a candidate for the Court of Common Pleas, he and I are having a roundtable discussion on Thursday on criminal justice reform and fair housing, a very similar event to what Judge Pappas and I have done in the past as well. And so it's an opportunity for me to kind of, talk about my work as a legal advocate and a law professor, but also advocate on behalf of a judicial candidate as well. And for those, of course, who want to, who aren't exhausted with campaigns yet, given all that's happening after the municipal elections here, you want to get involved with this, national congressional race. you can go to jerrydickinson.com. There is a volunteer tab. You can sign up, and we can use all the help in the world. This is a very, very exciting, progressive primary challenge against a 26-year incumbent. And so it's very exciting, and we could use all the help we can get. So yeah, there you go.
Yep, and Jerry's website is on there. It'll also be on Facebook, and it is a large race. So he will need lots of money, and it's never too early to start thinking about 2022. All right, Hilary, your turn. What do you have coming up this week? I know all about it, but nobody else does, so go ahead and tell them.
All right, we're knocking on doors. That's all we're doing until Election Day is knocking on doors. Every free moment come, like the post office, rain, sleet, snow, or shine. Hopefully we have no more snow because it's May, fingers crossed. Every weekend you can find us at 11 o'clock in my driveway launching a canvas for the next 2 weekends. Except for the Sunday before Election Day, we have a canvas starting at 1 o'clock with Judge Pappas's campaign, Nicola Henry Taylor's campaign, and Lisa Middleman's campaign as the last major canvas before Election Day. And we also need volunteers to work the polls for us. So there you can find out all sorts of information about the location and times for all of those things at my website, which is electhillary.com.
Yep, and
Oh, and Monday night, next Monday is our last speaker series, right?
yes, next
One more.
Monday is the last speaker series with the remaining 2 candidates. I probably would have forgotten that, so I'm glad you said that. The remaining 2 candidates on the slate for 8. We have Rena Watson and Chelsea Wagner on fines, fees, and our courts. So that will be our final speaker series to complete out the slate of 8.
How quickly 8 weeks goes.
Yep. So thank you, everybody. It's been great, and we'll see you next week at 7 o'clock.
Thank you, Hilary.
Everybody.
Thanks, everyone. Bye.